Hello and welcome to the in-news series of Drishti IAS. My name is Pooja Devedi. The Supreme Court, in a split verdict, has upheld the constitutional validity of 10% reservation for the EWS category. It was upheld by a 3:2 majority. The Chief Justice of India was one of the dissenters. So we will talk about that only. From the perspective of GS Mains Paper 2nd and from the perspective of prelims, it's important that you walk through this. So as I have already introduced to you the news, we will talk about the 103rd Amendment. Who can avail the EWS quota benefits? Is quota based on economic criteria valid? Is it a breach on the Constitution? The problem with the 50% cap on quota, which is according to the Indira Sohani judgment of 1992. Petitions. What were the petitions that were challenging it? On what grounds, basically? What was the center's contention? What was the verdict? And a question which is prelims based that I will ask you during the course of the entire segment. It will be in the middle of the segment. Supreme Court upholds 10% quota for EWS, that is economically weaker section, saying it is not a violation of the Constitution. What is the 103rd Amendment Act of 2019? This amendment introduced economic reservation. That means reservation will be provided on the basis of a benchmark that is set according to the economic status. It amended Article 15 and 16. It inserted Article 15 Clause 6 and 16 Clause 6 in the Constitution in order to promote the welfare of the poor who have not been covered under the 50% reservation policy that is provided for the other categories like SC/STs. Both the center and the states have the power to provide reservation to the EWS of the society according to this amendment. Now, who all are eligible to get the benefits under EWS? Persons who are not covered under the scheme of reservations, like SCs, STs, OBCs, whose family has a gross annual income below rupees 8 lakh only, and these are to be identified as EWS for reservation purposes. Income could be from salary, agriculture, business, profession, etc. It should be in this nature. And this income will be used to calculate your EWS status for the financial year prior to the year of application. Okay. Moving ahead, let's talk about another very important criteria. If a person has any of these, then the person is not in the EWS category. If you have 5 acres of agricultural land or above, residential area of 1000 square feet or above, residential plot of 100 square yards and above in notified municipalities, residential plot of 200 square yards and above in the areas other than the notified municipalities. And if the property is at different places, that will also be clubbed together to get the status. Now, is quota based on economic criteria valid? The questions that Supreme Court was mulling over were certain questions like, is the reservation based on economic criteria permitted by the Constitution or not? First that, because our Constitution is silent on this. Now, if the reservation is provided, will it go against the basic structure or not? Okay, that was another question that the Supreme Court was thinking over. Now, there are certain issues that were seen as a breach on the Constitution. Now, is it a breach on the Constitution if this amendment permitted the states to make special provisions, including reservation based on economic criteria, permitting the state to make special provisions in relation to admission in private unaided institution? Because public institutions are of course under the government, but private institutions, they are free to conduct their own affairs. Is it going to breach? Can it be seen from the prism of a breach of the Constitution if the government dictates, provide reservation in privately funded institutions? And also, is it okay to exclude the socially and educationally backward classes, OBCs, SCs, STs, from the scope of EWS reservation or not? Alright, moving ahead, now the 50% quota issue, which was pronounced by a 9-judge bench in the Indira Sohani versus Union of India in 1992, was also the problem. there it was seen that reservation should be provided in a manner that it does not breach the threshold of 50% in totality. That was also in question. Already 50% reservation was there, but by providing 10% more, the breach of the threshold was there. But because the center was having this contention, this argument that it is not inviolable, this threshold that was there, the upper limit should be there of 50%. It's not something that cannot be thought over again. So this was something the Supreme Court was thinking over. Now let's talk about the petitions which were challenging these particular issues on certain grounds. Economic criteria should never be the basis for granting reservation. This was something that was said by the petition. When we are providing, you can say, a reservation on the basis of social and educational backwardness, why not provide it on an economic backwardness as well? You tell me in the comment segment if you think it otherwise. And a fraud on the constitution, it was also said that because there are going to be people from already forward communities such as, you can say, Kshatriyas, Brahmins, they can also be under the EWS category. Socially, they are thought to be that they are forward, not backward, social, in the social hierarchy. But what if they are unable to move upward the economic ladder because they are tangled in a vicious circle? Why not provide them the opportunity of getting better education? So this was something the petition was challenging, but the government replied in an otherwise manner, saying that the 10% reservation is not going to have any impact on the other categories because other categories already have 50% of reservation plus 10% of reservation is there. Because of this only, the addition is there. It's not like the reduction has been done for the STs and OBC at 40% and 10% under the 50% criteria according to Indra Sawhney case, because there is an addition of reservation. That is why it is not going to have an impact on other categories. Also, there has been a creation of certain additional seats in different, you can say, sections as well of education, and this is the reason that none of the categories which were provided reservation earlier will be impacted. It's an economic justice what the government is doing according to the DPSP, according to the fundamental rights, that the government is saying we are doing economic justice, and it is not that we cannot, we are dictated by the, not dictated, but we are, you can say, directed by the DPSP to ensure that the socially and economically weaker section should also be uplifted. Then there, I have already told you, there is an upper limit on quota, but this is not a golden rule. It's not like it cannot be violated. Although we can understand from the perspective of the judiciary, certain times it can also happen, the Supreme Court can reverse its own judgments. It can also happen. So why not? Because of this precedence, there the last point holds water. The verdict is in the case Janhit Abhiyan versus Union of India with 32 connected matters. It was a 5-judge bench consisting of Chief Justice of India UU Lalit, Justice Dinesh Maheshwari, Justice S. Ravindra Bhatt, Justice Bela M. Trivedi, and Justice J.B. Pardiwala. So, Chief Justice of India UU Lalit and Justice S. Ravindra Bhatt, these two were the dissenting judges. They wanted to strike down the 103rd Amendment Act, but Justice Dinesh Maheshwari, Justice Bela M. Trivedi, and Justice J.B. Pardiwala, they upheld the constitutional validity, saying that the reservation is an instrument of affirmative action that the state does to ensure that an all-inclusive march towards the goal of an egalitarian society exists while countering inequalities. Again, another justice said that the reservation for EWS over and above the 50% cap does not violate the basic structure. Basic structure of the constitution, if not violated, then an amendment can be upheld, but we have to also ensure that other structure, apart from basic structure of the constitution, Another sort of injustice and passage is not there, saying that the ceiling by itself is not inflexible. Ceiling is not inflexible, that is what the Supreme Court has said. Here we are referring to Indra Sawhney case. In any case, only applies to reservations, which is envisaged by Article 15 clause 4, 15 clause 5 and 16 clause 4. Treating the EWS class of citizen as a separate class would be regional classification. So these are a different class, and as they are not earlier getting any sort of reservation on the earlier reservation basis, benefits on the earlier reservation basis, they can be treated as a separate class. And reservation is not an end, but a means. Nobody studies so hard so that they can know that they will get reservation. Okay. Now, the dissenting judges, they are saying that amendment by the language of exclusion undermines the fabric of social justice and thereby the basic structure of the Constitution. They are saying, the dissenting judges, Justice Ravindra Bhatt and Chief Justice of UU Lalit, they said that because you are providing the other categories reservation on a basis of, you can say, caste, but here you are providing it on the basis of economics, so there can be a division among the society, social division among the society, which is not in the healthy spirit of the Constitution, but it is a violation. Now, if I ask you a question, you have to tell me in the comment segment, what was the 19th Amendment Act, 100th Amendment Act, 102nd Amendment Act and 101st Amendment Act. You can write the Amendment Act from 99th to 102nd, and then I will take your names, whoever is going to answer this question correctly. That's it. Thank you so much for watching.